right, we're back on the record for the continuation hearing addressing the initial removal of the children. I've had the benefit of a bench conference before we came on record today, which we'll address after appearances.
Lee Heiss, lawyer, guardian ad litem.
Ms. Stasia Thomas, counsel for the department. Ms. Holmes.
Caitlin Holmes, CPS, Washtenaw County.
Elizabeth Burry, foster care specialist, Washtenaw County.
Michael McFarland, representing mother Malika Rembert, who is not in the hall and I've had no contact with.
Stephen Johnson, father of all three Johnson children. I have been in communication with him, but I don't know if he's on Zoom or not.
I think he was logged in, but we were late. We took a bench conference opportunity, and I think he was logged in, but he's no longer logged in.
Okay. Well, I have been in communication with him.
Very good. All right, as it relates to the bench conference, any comments, Ms. Thomas?
Your Honor, they're reviewing my file. I still am not sure that we have Malik served with notice of these hearings or proceedings. I will allow Ms. Heiss to give further detail on that, but that is one of my main concerns on this matter, is proper service and notice to mom.
Probably Ms. Holmes is who you are looking for, or did you mean me? You said Ms. Heiss for the service issue.
Nope, I'm sorry, Ms. Heiss, I just meant for the other
Oh, yes.
issues that we discussed.
All right, any other comments about the sidebar, gentlemen?
Oh, you are.
I think we should dismiss this case against Mr. Johnson. There's nothing here.
Comments, Ms. Heiss?
No comments further, thank you.
All right, very good. Well, I think we're gonna need some witness testimony from Ms. Holmes. Regardless, Deputy, do you swear please, Ms. Caitlin Holmes?
Ms. Holmes, please raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
One moment. Looks like we have had, I believe this is Mr. Johnson. Yes, I thought so. So he's having some trouble connecting to audio, but he has joined us by Zoom. All right, so Ms. Thomas, as you address your questions with Ms. Holmes, I would like to know if there are any affidavit of parentage forms. I did not receive any, even though I ordered DHHS to supply those and to advise on the status of paternity investigation, as well as an update on the home investigation of the father's home for possible placement, the FTM, basically the things that were ordered at our last hearing. I'd like some updates on those as you explore your other issues, please.
Thank you, Judge. Ms. Holmes, as it relates to the children, where are they currently located?
They're currently in the care of their father, Stephen Johnson.
And do you know if a DH-9 was provided?
She's sworn in.
Yes.
I'm sorry.
She was.
I wasn't paying attention.
I'm sorry. Could you repeat that?
I did not finish my question. As far as the DH-69 indicating that there was a move to the children, do you know if that was filed? I'm not sure that you'd be the appropriate person to ask, but are you aware of that?
Yes, it was filed.
Okay, and was that sent out to the parties? I don't believe that my records have it, nor the LJLs.
I
So
believe
do I.
Ms. Burry, she sent it to the court, and I'm not sure if it was distributed. I did send it to Ms. Heiss recently, as she requested it.
Okay, thank you for that. And given that the children are with Mr. Johnson, is it your opinion that there's no longer a imminent and substantial risk of harm to them?
Yes.
And as it relates to the children's AOP numbers, do you have those?
I do not at this time. We have not received them.
Okay, and when were those requested from the state?
I do not have the date off the top of my head. I would have to double check with the my supervisor.
And have you had any contact with Ms. Rembert?
Yes, on August 1st, she reached out to me from a phone number that does not belong to her, and she stated that the phone number that she reached out to would not be a good number to contact her at. And I was able to inform her of today's trial, as well as I received an email address from her so I could send her the petition as well as the removal order. I have not had contact with her since then.
And did you file a proof of service indicating that you had provided the information to her?
I have not.
Okay.
Oh, the record should reflect Mr. Johnson's dropped out of the meeting, but he did connect audio and I know was present for most of Ms. Holmes' testimony so far.
Okay. Ms. Holmes, is there any reason to continue this petition at this time?
At this time, we have not had contact with Ms. Rembert, and we would like to continue attempting to get contact with Ms. Rembert in order to ensure the safety of her children when it comes to her.
Okay, thank you. Your Honor, I have no further questions of Ms. Holmes.
Ms. Holmes, do you know when those DHS 69s would have been filed? I checked with my clerk's office this morning specifically to make sure I had anything that was supplied in anticipation of today's hearing. And they informed me they did not have anything.
I'm not certain of the exact date. Ms. Berry might have she might know the exact date as she was the one who filed them.
Thank you. Questions of Ms. Holmes, Mr. Brooks?
None.
Mr. McFarland?
We didn't do a publication for my client, correct, Ms. Rembert?
I'm sorry, could you clarify what you said?
We did not do a service by publication for my client, correct?
Yes.
Nothing further.
Ms. Heiss?
Have you, Ms. Holmes, been to the home where the children live?
Yes.
And that's in Hudson, Michigan?
Yes.
Thank you, nothing further.
Any redirect?
No, Judge. Thank you.
Any other witnesses?
If Ms. Berry could be sworn in just to confirm the filing of that DH-69, please.
Thank you. Deputy Ames, Ms. Elizabeth Burry, please.
Please raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Ms. Berry, can you just give us a brief recap of when you filed that DH-69 indicating the children were moved?
It was filed on August 10th.
And did you file a proof of service noting that you had also provided it to the parties?
No, I did not.
And just for our record keeping, what email address did you file that DH-69 with?
I sent it to Celeste Floors. It was the same person that I originally got. We got the court orders from saying that the children could be returned home to Mr. Johnson, and she told me to send the 69s over to her. But I did not have any of the other contact information to send it over, so that's why it was just sent to that email address.
Okay. Thank you. Your Honor, I have no further questions of Ms. Berry, and on that point, it does look like my file has it. I don't believe my secretary would have intended on filing that for the department. Typically, that is something that our workers do. So I do have that, and if that was my responsibility, I do apologize for not forwarding that to the other parties in this matter so that we knew the update on the children. I still don't, I think my problem still lies in the fact that I don't have a proof of service for mom, formally indicating that she was served. We have children with a parent who is deemed safe and appropriate. There no longer seems to be an imminent or substantial risk of harm to them. I guess I have some concerns about parentage. But with the children in Mr. Johnson's care, I believe that he has the ability to file for custody, and we would hope that he would do so in order to appropriately safeguard them.
Any witnesses or argument, gentlemen?
I have one question I'd like to ask this worker.
Oh, by the way, your client has rejoined us.
Okay. Ma'am, Ms. Burry. I find her on the screen.
She's in the bottom left.
Yes. Before bringing this case to Lenawee, did you guys try to file this in Washtenaw County?
I believe that would be a question for Ms. Holmes. I'm not sure if we tried to file in Washtenaw or not.
We did not try to file in Washtenaw.
Thank you. That's all.
Just comment when it's done.
Mr. Brooks, did you want to hear from your client, or do you have any comments today?
I think he'll be fine with what is about to happen.
Comments then, Mr. McCrone?
I would agree with Mr. Brooks. The kids are safe. Returned to a parent. I think this case should be closed. My client has not been properly served, Your Honor. I don't know how much more time this case dragged on for multiple months with my client not being served.
Ms. Heiss.
Thank you, Your Honor. August 18th, I realized, I contacted the foster care home and they didn't have the children. So when DHS 69s are filed, when they are distributed, it helps me to avoid that error so that we all can show our professionalism and not look like we don't know what each other are doing. But on the 18th, I emailed to Caitlin and she was on vacation. She got right back to me, got me some of the information, and then on August 23rd, got me the a copy of the DHS 69. So I was able to reach out to Mr. Johnson, who lives here in Lenawee County. He offered me a visit the other morning, but I had a new abuse and neglect come in, and so we rescheduled for last night. I have seen the children face to face. Their home is clean. It has, the children are clean. The children are, all three children appear to be very well cared for. If there's anything wrong with their environment, it would require a lot of investigation, because what I saw were healthy children, a father who is interested and plugged in their care. He is motivated to take care of them all and to protect them from their mother. And in my estimation of the situation, he shouldn't be a respondent. Mother may need to be a respondent, but we at least have to find her and serve her and have a hearing on the allegations. So I don't oppose dismissing the case. Thank you.
The court finds all interested parties were given notice, with the exception of Ms. Rembert. She may have had notice, but we don't have proof of service indicating that she was served by email. I think it's safe to say she did have information about this, at least as a courtesy from Ms. Holmes during her conversation with Malika Rembert. As I stated before, obviously Ms. Rembert, we know, is around. We have evidence by way of more little humans from these two parents. So this petition will not move forward. I will be dismissing it. But what I would encourage Mr. Johnson is that in the event you are in contact with Ms. Rembert, that you encourage her to undertake some of the services that were set up for her at the last juncture, so that if your family is pulled into a CPS case in the future, she can show that she has made some progress. If you feel that she is competent to be around your children, then we would hope that you would feel comfortable enough to encourage her to undertake those services with her own chosen service providers. And that would benefit you and your family and your children, which is really what the goal of the court is in the future, is just to have safe parents and parents that are able to take care of their children. And in order to do that, you have to take care of yourself first, and that includes Ms. Malika Rembert as well. So it will be the order of the court that the petition is dismissed. Mr. Johnson is warned that exposure to Ms. Rembert, in the event she has not undertaken services to remedy some of the risky behaviors that we've seen from her in the past, will inevitably cause further confrontation by CPS in the name of looking to keep the children safe. But as of today, we do not have enough evidence to say that Ms. Rember is actively a present and imminent danger to the children. And Mr. Johnson has been investigated, the children are placed with him, and that has been deemed safe. So for those reasons, the petition will be dismissed. Okay, we are on record today. Continuation of the prelim on this particular file. We made a little bit of headway last time we were here, and we are getting ready to.
I'm sorry I wasn't able to attend, but I had a conflict and I couldn't break it.
Well, that's all right. We're back, and you've been able to talk with your client, so we'll get started. Let's do appearances, please.
Good morning, Your Honor. Nicole Underwood, legal guardian ad litem for the minors.
Natasha Thomas, counsel for the department.
Chris Morak with the department.
Michael Brooks, I am the attorney for the father.
Stephen Johnson, I am the father.
Michael McFarland, representing Malika Rember, who's joining us on Zoom. Is she on screen?
I was just looking for that.
Just call.
Okay, it looks like we have quite a few, like I have
Harper Light.
Veronica Bresnay, Paula Mary, Heather Barris, Amy Fullerton also in the waiting room. How many of them do you want?
Bueno Veronica is their foster care supervisor.
Okay, so we'll let her in. You want anybody else?
Paula.
Okay. Heather Barris, Amy Fullerton would be the only other department.
They might be for the trial.
Yeah, okay, perfect. There she is. All right, Malika, can you give us your name for the record, please?
Malika Rember.
Hello, welcome. Okay. All right, I think we went over a lot of what we needed to do for our purposes of the prelim last time. There's an active Native American heritage search underway. If there's any update on that, I'll look forward to that. Mom wants to enter a plea. Dad wants a jury trial, which we set.
Your Honor, we don't want a jury trial. My client and I have discussed it in the hall, and we don't want a jury.
You like a bench trial?
Yes, please.
All right, so we'll leave that date.
But I would like you to ask my client about this.
All right, Deputy Ames, would you swear in, actually go ahead and swear in Ms. Malika Rember and Mr. Stephen Johnson, please.
Mr. Johnson?
Yes.
You can raise your right hand. Ms. Rember, please raise your right hand to be sworn in. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Yeah.
Thank you.
Okay. All right, Mr. Brooks. Does your client have a copy of the petition? Or maybe I'll just, Mr. Johnson, do you have a copy of the petition?
Sir?
Yes, I received it. Yes, I don't have it with me if that's what you're.
Well, that's okay. I just need to make sure you actually got a copy of it. And you've had a chance to talk with Mr. Brooks?
Yes.
All right, so last time we were here, you had another attorney just briefly, and we set a jury trial, but do you want a jury or a bench? Meaning in front of the judge, me, or in front of a jury?
I was hoping in front of the judge, and the last attorney, like I was trying to reach out to her at the end of it, I really wasn't fully knowledge on the directions because I don't feel like that was the attorney made me the right decision. So I feel like I made a decision unknowingly of other options.
Well, it's okay with me either way. All right, so we've got you scheduled for December 20th, and you can still have that date. We'll just hear the case in court here without requiring the jury to be present. So we'll have the same date there.
So we are going to trial.
It's up to you. So you have the right to admit or deny the allegations in the pleadings. I'm sure Mr. Brooks has talked with you about that. If there's enough that you want to admit, then I would decide whether or not that qualifies as a violation of the statute to take jurisdiction, which obviously is a lot of legal terminology. So if you have questions about that, Mr. Brooks is well-versed in these cases and will be able to talk you through that. But maybe this is a better question for him. Mr. Brooks, have you talked to him about how he wants to proceed?
I have. My client does not believe he's guilty of anything, and we want a trial.
All right.
My client doesn't want a trial. He just wants you to give him his kids back today, but I haven't got that to offer.
Well, he can ask for a place. You can ask for placement today, and I'll hear that argument on that piece as part of today's hearing. So today I've just got to decide, and I already have actually, probable cause has been established to authorize the petition. but you can continue to request placement today. I can also set it for an evidentiary hearing on the issue of placement. I can't do that today. I might be able to get it in within the next week or so. Does that sound like something you want to try?
In plain English, if you admit enough of this petition, court will take jurisdiction.
Well, I'm talking about placement.
No, she already took jurisdiction, and today we're just here to discuss the placement. And
Well, both questions are unanswered, frankly. So they're separate questions. One is whether or not to officially remove the children and place them with your father. And the other one is whether or not I should take jurisdiction over the parents. And you have the right to a trial on the issue of whether or not the court should take jurisdiction over you. And the kids, really. I don't think
My
that
client is under the impression I told him this case was not going to amount to anything and I was going to get his kids back today. I'm sorry he got that impression. All I really meant to say is it's not a strong major case. That doesn't mean it's going to get decided today. But at some point, you will hear the evidence, and that will determine whether you think this is significant or not.
On the question of removal, the situation right now, as I understand it, is that there's an agreement to let the kids stay at your dad's. Now, the department, and we had a brief bench conference, I want to put this on the record. I talked with the attorneys before we got on record. The department is asking for formal placement with your father, which would trigger things like funding, parenting time, and some other slightly higher structure. But it would essentially be the same plan, or it would be like the legalization essentially of the plan that you're currently under. So if you want to continue the safety plan until we can come back for an official hearing on removal, we can do that. That sounds like what you want to do. Is that right, Mr. Brooks?
Understand what the judge said.
yes, I understand. I understand what you said, but the part I don't understand was the safety plan because I haven't been submitted any paperwork, or I haven't been sat down with, I haven't been even told what I can do about my allegations. So my particular point of view that I'm focusing on is how can I agree to a safety plan that I have everything looked over. And Chris, besides the day that my kids were removed, this is the first time that CPS even reached out to me. We haven't talked about any safety plans. We haven't talked about what I can do for your reunification, whether it's temporary or long term. We haven't talked about what I can do for myself. I haven't spoken to anyone. Only thing that they said to me was, I'm removing your kids. And they disappeared, and they called me today and tried to get me a ride to court.
All right, so your kids have not been officially removed. My understanding is that there's an agreement that you're letting them stay with your dad for now.
It was an agreement that I made under the impression that I was given no other options from the influence of CPS.
Okay.
So it's a great agreement because my father is very great with kids, but it still is a lost, empty agreement because I don't understand exactly what I'm doing. I'm just doing what's best for my kids for now and hoping that the judge can tell me, you know, when my lawyer kind of explained it more of my rights now.
Right. So
And my problem is, I have been so inundated with cases. This gentleman and I have not had a chance to sit down quietly and privately and discuss what this process is like. As you are aware from your record, another lawyer was sitting in here on the first hearing. So in the meantime, frankly, I've been in this room most of the rest of the time.
Frankly, I think it sounds like we probably need to have a little more time, obviously, for you guys to chat. And we have another case this morning that was set that I need to allow to continue.
It's a
Judge
termination.
Costello, is looking over. So
We have a plea, Your Honor.
yes, what I would like to do is take Ms. Rembert's plea and recess on the question of removal for today and let you continue talking more about that. We can either come back this afternoon, or if you want to talk about continuing to let the kids stay with your dad, we can come back And your dad would be able to supervise parenting time, as far as I'm concerned. Like, there shouldn't be a prohibition against you seeing your children, if that's part of the question.
My client likes his dad just fine, but he is opposed to that. He wants his kids back today.
All right, so then we'll have to come back this afternoon.
Respectfully, Judge, I'm not trying to pressure anyone to any legal decisions. I just know this is the first time I was able to get any type of, insight on the case was today. And for 3 weeks without my kids, sitting back wondering, I finally get in this courtroom. I'm just hoping and expecting some type of closure to the allegations that's being held against me. Not complete closure, but at least some understanding.
Right, well, let's do it. I can take up the case again at 1 o'clock this afternoon.
But
Sure.
I want to leave it up to my lawyer. I'm not the lawyer, whatever.
I don't like
Yeah.
going in half-baked, which I have told him I would be doing today. If we went into this right now.
Oh, really?
Yeah.
Okay.
Right. It's my understanding this determination trial is going to go into the afternoon.
Okay.
Evening started.
Right. Well, we're a bit busy here today. So let me just do this. Let me get Ms. Rembert's plea done. Then we'll take a recess and we'll let all the attorneys sit down and try to figure out how to schedule this so that we can try to avoid making everybody who's currently here continue waiting. We'll try to come up with a better plan on schedule, but let's get Ms. Rembert's plea done. Is that okay? Any objections? Speak now. All right, Ms. Rembert.
Take your seat, sir.
Can you hear me okay still?
Yeah.
All right. So my understanding from Mr. McFarland, just briefly before we came out, is that you wish to admit to the allegations in the petition. In other words, you want me to consider all of the allegations in deciding whether or not to take your plea. Is that right?
Yeah.
Okay, so I'm going to go over your rights with you. You have the right to have the petition read in its entirety, or you also have the right to waive that. Would you like me to read it out loud on the record, or would you prefer to waive that?
I prefer to waive it.
Okay. If I accept your plea, you are giving up your right to a trial by a judge or jury, the right to have the petitioner prove the allegations in the petition by a preponderance of the evidence, the right to have witnesses appear and testify under oath at trial, the right to cross-examine witnesses, and the right to have the court subpoena any witnesses that you believe could give testimony in your favor. Do you understand you'll be giving up or waiving the rights I've just indicated to you if you admit the allegations in the petition?
Yes, ma'am.
All right. In regard to the consequences of your plea, or in other words, what will happen, the court will do the following. There will be continued investigation by the caseworker to see what the problems are in your family and how and whether they can be solved. The court could dismiss the case if there's no need for the court to be involved. If it appears that there's a problem that may be solved, the court can make the children temporary wards of the court, place them with mother or father or with relatives or in a foster home, and order programs for you and your children, such as counseling, drug and alcohol treatment, assessments, and parenting classes. If it appears that you will not be able to provide a proper home for the children in the reasonably foreseeable future, the court could terminate your parental rights. In regard to the plea itself, the plea can also later be used as evidence in a proceeding to terminate your parental rights. Do you understand the potential consequences of your plea?
Yes, ma'am.
Do you have any questions about any of the information I've given you so far?
No.
I understand you're coming to us from a rehabilitation facility today, is that right?
Yes.
Well, congratulations on your continued recovery, but I have to ask you this question anyway. Are you currently under the influence of drugs, alcohol, or anything else that could impair your ability to understand what you're doing right now?
No, I was drug tested. It was all clean. No.
Great. Okay. Is anyone making you admit to the allegations in the petition?
No.
Is anyone threatening you in order to get you to admit to the allegations in the petition?
No.
Okay. Would you say your decision to enter the plea is one you've made of your own free will?
Yes.
Has anyone promised you anything in order to get you to enter a plea?
No.
All right. Very good. As to the factual basis of the plea, Ms. Thomas. Or actually, no, just kidding, because this was going to be a no contest. All right. Mr. McFarland, would you like to do your client on that?
Yes, Your Honor. I guess I should say one thing, Your Honor. That'd be number 4, which is the Native American heritage. It says that the subject minors are not members or eligible for membership, then that's up in the air. Just, I think the court understands that.
I do, yes.
Thank you. My client will admit that she's the mother, Your Honor. She will admit the allegations against her in their entirety, including last time we were in court, she wasn't quite sure about all the investigations done by CPS, but she will believe that that will be their testimony on number 18, the CPS history. So that's the only change. Now, that was going to be a no contest, but we will admit number 18 also, in addition to everything else we said we would admit last time in court.
Okay. So why don't you give me the summary of the issues that your client and the department will be working together on in order to help restore her to a safe
Sure. Number one, Your Honor, is a drug addiction. She's in rehab right now. Number two, we anticipate there'll be a psychological evaluation ordered, and then she'll be, that will be incorporated, the recommendations, into the case service plan. I anticipate visitation will be an issue. What is available at Harbor Light, who supervisors may be, transportation may be an issue, housing is going to be an issue, Your Honor. Parenting classes are going to be an issue. She has been in the system before, so it'll be understanding what she did not benefit from before and working on those items, Your Honor.
All right. So, Malika, did you hear everything that Mr. McFarland just talked about?
Yeah, I do want to state that I did do a psychological evaluation already, and I'm on medication.
All right.
CMH then may also be a component on this, Your Honor. She's on medication.
All right. So it does look, Ms. Rembert, like obviously last time you were here, you were appearing to us from Lenawee County Jail, that you have some criminal matters that need to be resolved, that you need to work on your sobriety, which is why you're at rehabilitation, some parenting skills, and making sure that you're able to maintain housing and employment and safe and clean housing for your children. Would you agree with that?
Yep.
All right, I do as well. Based on my review of the petition, is there anything else that you wanted to say today that you're ready to work on?
Not as of right now.
Okay.
I mean, not right now. I would say my mental health, but I'm working on that right now too here.
Great. Glad to hear. All right. Are the attorneys satisfied with the advice of rights and the factual basis of the plea?
Yes, Your Honor.
I am, Your Honor.
Does the lawyer or guardian ad litem think it's a good idea for the court to accept the plea, as in it's in the best interest of the children?
I do believe so, Your Honor, yes.
Thank you. The court does as well. I also find the plea to be knowingly, understandably, and voluntarily made with an understanding of the consequences. You'll be able to continue talking about how to tackle the challenges that were outlined today, Ms. Rembert, by way of a family team meeting wherein they'll put that case services plan together. You've seen those before, I know, but I would encourage you to take a look at it, talk with Mr. McFarland about it if you can. And the next time we come back will be for purposes of the disposition, where the court will look at that same plan to determine whether or not it's appropriate and tackles the issues. I also find that the statutory grounds have been met to find that there was a violation of the statute 7112A.2B. I think it's 1 and 2, or whichever subsections specifically the department is claiming, but mainly that the house is, and our environment is unsafe as a result of many of the things that have been talked about. The criminality, the need to address mental health, the condition of the home, and the instability in summary. So the order will reflect those findings. And we can do the initial disposition on your case. Well, I can do it in a couple of weeks, counselors, or otherwise we're running into Thanksgiving. And we may have to ask you to consider waiving your 28 days. It's up to you.
This is a question, Your Honor. Might there be some type of supervised Zoom parenting time or something like that in the interim, then I think that we would waive the timeframe.
Well, the parenting time, I'm sure, will be subject to the facility where she's at.
Correct.
So I would look for the department to have a meeting with them or to really investigate that to find out how Ms. Rembert can best facilitate her relationship with her children.
Your Honor, my client would like the court to know that he and this young lady have not been together for quite some time, which I read between the lines to mean they don't get along.
Okay, well, right now I'm just trying to find a disposition date. So I can do a remote disposition on November 27th at 9 a.m.
That'd be fine, Your Honor.
Judge, I'm not available, but I think we have this set for a pretrial for Dad on some day.
I thought we did too. Monday the 25th, it looks like.
That'd be fine by us too.
Yeah, if we can maybe set it for just on that day.
All right, let's do that. Monday, November 25th at 9 a.m.
And Your Honor, if we could also, when we're off record, get a email address and actual address for my client.
Sure.
My email address?
Hang on, we're not on the record on YouTube, I guess. Are we on YouTube, Your Honor?
Right, yes.
So we'll wait till we're off YouTube, Malika.
Okay, so we're gonna formally recess on this case anyway in just a few minutes. Do you have any questions right now, Ms. Rembert?
No.
Okay, so I'm gonna be counting on the department to work with you to put together your case services plan and to talk with you and wherever you're staying about what parenting time looks like. Is there any other issues between now and we come back that you would need to have me consider?
No.
Okay, well, then that's all for today officially. And the request for removal made by the department. This is a continued prelim from last week as it relates to Mr. Stephen Johnson specifically. Ms. Malika Rembert is present with us today, although she absolutely has a right to be here for purposes of the process of her case in particular. She did enter a plea and is set for disposition on November 25th. And the names of our participants, please, and then I'll let y'all review what's been happening with regard to a brief conversation pre-record about exhibits.
Good afternoon, Nicole Underwood, legal guardian ad litem for the minor children.
Ms. Sasha Thomas, counsel for the department.
Chris Cornett from the department.
Michael Brooks, I represent the father, Mr. Johnson.
Could you introduce yourself, please?
Sorry, Your Honor, my name is Stephen Johnson, I'm your father.
Michael McFarland, representing Malika Rembert. Malika, please tell the judge your name.
Malika Rembert.
Thank you.
Thank you. All right, let's revisit the issue about a couple of exhibits that started happening before we got on record, Ms. Thomas.
Thank you, Honor. Mr. Brooks had provided us with photos of Mr. Rembert's home. We did have a chance to review those, I believe, at our last hearing date, which was on 11/7. Not sure if we ever got on the record for that. That day was quite a blur for all of us, I believe. But I do recall reviewing those, and I believe that Ms. Underwood has also seen them. And then additionally, the department, given that this is a contested preliminary hearing, or removal hearing, the department did print off photos as well of the conditions of the home at the time that the petition was filed or the investigation was happening. So we allowed for a moment for the other attorneys to look at those as well.
Yes, I do want to clarify, it's not really the prelim. We accomplished that piece. I think it's just more the removal questions. Okay, any additional comments about the exhibits or anything else before we begin, Mr. Brooks?
Well, I showed them mine, she showed me hers. I don't think either of us have any objections.
To the admission of the proposed exhibit A from your client?
My clients, and I have no objection to the submission of her photos.
Ms. Thomas.
Your Honor, for purposes of the removal hearing, I would call Mr. Korniak would call him as a witness to be sworn in and then lay foundation for the photos and admit them through his testimony.
That's how the only way I would agree, Your Honor. I was going to suggest the same.
All right, very well. Mr. Brooks would like his 14 photos admitted. Do you have any objections to that?
The only thing I would just ask for the dates of when they were taken.
Would you like
So maybe lay a foundation before we admit those.
So we'll just table that request, Mr. Brooks. I'll hold on to them. I have not looked through them other than to count them. I think there's 14.
Well, I think it would help.
I think the
because
date
I
is
got
on
it.
Saturday.
No, sir, don't do that.
Sorry. Sorry.
I would prefer to get that established before we start, because I intend to question the witnesses about to go out about my exhibits as well.
All right, Deputy Ames, why don't you return this packet over to Mr. Brooks?
This would
There's
just take less than a minute.
I think if you want to impeach the witness on those, that's up to you. Ms. Thomas technically goes first with her presentation. So there's no stipulation accepted at this time. So I can't look at those until and unless there's been an admission of those, and I'll let you navigate it from there. I have full confidence that you can handle it. Any other comments or issues before we get started?
No, Your Honor.
Your Honor, I guess we all met kind of back in chambers and that this was not scheduled today. Or I don't know if it was or wasn't specifically, but my client is joining us by Zoom. I understand that she does have some treatment appointments to make. So I'd like to at least ask her if she can stay for an hour at least, or half an hour, 45 minutes, or what her opinion is, if I can ask.
Mr. McFarland, you should have accomplished that prior to beginning our hearing this afternoon. I'd like to get started. I know Ms. Underwood has things to get to as well. So why don't we just try to make the best use of our time as we can?
Well, why I'm saying this for the record is that she wasn't given notice of this, Your Honor. So I want to make sure that she has any time constraints.
She's had the same notice that the rest of us did, frankly. So I'm going to deny that at this time. Ms. Thomas, your first witness.
Thank you, Your Honor. Call Mr. Kornack.
Mr. Kornack, come on up to the witness stand.
You swear or affirm to tell the truth, the whole truth, nothing but the truth, so help you God?
I do.
But there's a Kleenex next for your cup.
Thank you.
Hey, Ms. Thomas, whenever you're ready.
Thank you, Your Honor. Mr. Kornack, can you say how you are familiar with this family?
Well, I was assigned this current investigation on the 16th of last month.
Okay. And so you are a CPS investigator for the department, is that correct?
Correct.
Okay. And you drafted the petition that's before the court today?
I did.
Okay. And for purposes of the removal hearing, at this point in time, do you believe that during your investigation, the conditions that you found the home in pose a substantial risk of harm to the children's life, physical health, or mental well-being?
I did.
And what were those conditions that would pose such risk?
There were remnants of drugs found in the home. There was fecal matter on blankets in coolers and 2-liter bottles. The drugs that were found, the dead cat that was found.
Mr. Kornack, do you have photos of those conditions with you right now?
I do.
Can you hold up the photo of remnants of drugs found in the home? And I know it's a little hard for all of us to see, but we've been able to see this up close in person. Can you describe what you are stating are remnants of drugs?
The corner of a plastic baggie here and here.
Okay, and so let the record reflect, there's a corner of a plastic baggie on what appears to be a carpeted floor. And Mr. Kornack, in the corner of those baggies, what is contained therein? Are you aware?
It was reported that cocaine was.
And who reported that to you?
Law enforcement.
Okay. How old are these children?
They are 4, 3, and 1.
And what room was that, to the best of your knowledge?
I am not sure what room this is.
Okay. You also say there was fecal matter found in the home. Is there a photo that in your possession that can reflect fecal matter or urine found in the home?
Yep.
Okay, and Mr. Kornack, what are we looking at there?
This is a blanket with a brown stain that was reported to be fecal matter.
Is that on a bed?
Yes.
And then you also mentioned a dead cat in the home. Do you have a photo of a deceased cat in a cereal box on you?
I do.
Can you please show that for the record? Your Honor, please let the record reflect. There's a Captain Crunch Berries cereal box cut with what appears to be a white and gray kitten stuffed on the inside. Mr. Kornack, Why do those conditions pose a risk of harm to the children?
There's health concerns, there's criminality concerns.
By any chance, at the time of the investigation or the time of removal, did you happen to do any drug screens on the children?
On the children, no.
Yeah. So we're not sure if the children came into contact with substances that may have entered their system?
No.
Was Mr. Johnson screened for any substances?
Yes.
And what came back positive?
It's positive for cocaine and marijuana.
Did you discuss those findings with Mr. Johnson?
Yes.
And did he admit to any use?
Don't know that he ever admitted.
Mr. Kornick, how did this complaint come in front of the department? Do you know who called it in?
I do.
Are you allowed? I know that sometimes it's supposed to be confidential.
It is.
Okay. Was this ancillary to any criminal investigations?
Yes.
Okay. And is law enforcement, did you or law enforcement take those photos?
Law enforcement.
To the best of your knowledge, are there any criminal charges pending, or will there be any, to the best of your knowledge?
I don't know if there's been a decision that has been made as far as criminal charges, one way or the other.
Were you aware as to why law enforcement was at the home of Mr. Johnson?
Yes.
Can you give us any information on that?
Due to drug activity.
Just a minute. I think we need to lay a foundation for this next answer. Objection. Hearsay.
Well, the rules of evidence don't apply at a preliminary or removal hearing, and I believe the court would give it the weight appropriate for whatever Mr. Kornick says. I can ask a foundation a little more on that. I can try at least.
Mr. Brooks, you will also have the opportunity to cross-examine. I believe the question was simply one that was put to law enforcement about part of the investigation.
You know what? I do agree with her as far as it goes. I withdraw my objection.
Very well.
Okay, Mr. Kornick, in speaking with law enforcement, did they give you any indication why they were at the home?
Due to drug sales.
Okay, so they believe that there were drug sales happening out of that home?
Yes.
When law enforcement arrived, to the best of your knowledge, were the children home?
Yes.
And was Mr. Johnson home?
Yes.
Were any other adults in the home?
No.
And at this time, I know that we've already discussed Ms. Rember ancillary to this case, but at that time, was she, as the other legal parent, available to provide proper care and custody of the children?
No.
What did the department do then to safeguard the children at that point in time?
That night, or during the raid, law enforcement took the children to the maternal grandmother who lived nearby. Maternal grandmother was unable to care for the children. That's when we found the paternal grandfather and aunt who were able to care for the children.
And in Mr. Johnson's defense, he was agreeable to a safety plan with the children being with his dad?
Absolutely.
Okay. And is his father, according to the department's background checks and whatnot, is he an appropriate caregiver for the children?
Yes.
And the children have been in this safety plan for quite some time, is that fair to say?
Yes.
Okay. So I believe your petition says the raid occurred on October 17th?
16.
16th? And the children have been with their grandfather since October 17th?
No, it wouldn't have been the 17th. It would have been a couple days later.
Okay. So they were with grandma for a few days and then went to grandpa?
Yes.
Okay. And has Mr. Johnson followed a safety plan in allowing the children to maintain safety at his father's home?
Yes.
And are there additional supports in that home to assist grandpa in taking care of 3 little children?
Yes.
Okay. And who is that individual?
The aunt.
Would that be
the children's aunt?
The children's aunt, and so is that Mr. Johnson's sister?
Yes.
Okay. And does she currently reside in Michigan?
She is visiting. She's a resident of Texas.
Did the department complete clearances, background, like central registry, and criminal clearances for Texas for this individual?
We were able to do CPS or the equivalent of in Texas for her, and she was clear. We weren't able to do a criminal history at this point, but we did run her on the National Sex Offender Registry with no hit. She also has no hits in Michigan for the Central Registry or criminal history.
Thank you for that. And if the court were to maintain the removal of the children, do you believe that the department, if the court were to remove the children today legally and give the department placing powers and authority of the children, is it the department's position to maintain the children with their grandfather and their aunt?
Yes.
Now, Mr. Kornak, you had an opportunity to look at the photos that Mr. Brooks has shown us today, correct?
I did.
And in those photos, is it fair to say that the house looks cleaner?
Yes.
And with that house being cleaner, what is the risk of harm to the children if they are not removed and put back into Mr. Johnson's care and custody today?
I still concerned about the criminality. And I would like to also see the home also, not just pictures.
Mr. Kornak, in your petition, I believe that it looks like there's a history with CPS involvement, mostly as relates to Ms. Rembert. But the children involved in that, in Ms. Rembert's CPS history, are those also the children that are legally Mr. Johnson's?
Yeah, well, Ms. Rembert has a number of children, but these 3 are hers.
And so in the past, has Mr. Johnson been an appropriate caregiver for the kids?
Yes.
And have you had any communication with him that would indicate that he doesn't know what's appropriate for children?
As far as being a parent?
Let me rephrase that because that is a very big question. I apologize. In any of your communications with Mr. Johnson, do you have concerns about his ability to appropriately parent or safeguard his children?
I have concerns about his house, the fecal matter.
Yeah, please see if you can turn that ringer off. It's way too close to the actual alarm also that goes off in here occasionally. Anybody else in the house?
I have concerns about the potential drug sales out of the home, potential criminal charges that could be pending.
Thank you. With that, Your Honor, I have no further questions of Mr. Kornak, and I would ask the court to accept the photos that he has with him today that counsel has been provided an opportunity to look at.
I would like the board here first.
Do you have any objections, Mr. Brooks?
Well, in light of the testimony I just heard, I do.
Okay, all right. We'll table that. Mr. McFarland, would you like to go first?
Sure. The last picture, you testified that this was found in the house. That was your testimony, correct?
At the house.
Oh, you said in. But
okay.
So what did you see? I don't want to know what the picture is, but what did you see?
I saw the dead cat at the house.
Okay, where at the house?
On the side porch. There's a front door, but it's on the side of the trailer. It was on that porch near the front door.
Oh, no way of knowing if that cat came from in the house or whether that was a stray from the neighborhood who happened to crawl there and die, do you?
I do have an idea.
How so?
Mr. Johnson told me that it was their cat.
He say inside or outside cat?
He said it was their cat.
You have no idea what time the cat died, right?
No, I don't know what time the cat died.
Do you have any type of police test results for what you described as allegedly cocaine?
The police tested it and it came back positive for cocaine.
I'm asking, do you have any police results?
The police results?
Do you have them physically?
I have a police report that states that.
Is that what you saw, that photo? Did you take the photo? You didn't.
I did not.
So did you see that white substance on the ground or not?
I did not.
So that's not your observation that you're describing.
It's law enforcement's observation.
Okay. And the third picture photo was a photo of what? Cat feces, right? Is what you,
Feces.
or of some type of feces, is what you said.
I believe so, yes.
Once again, is that what you observed or not?
It's what law enforcement has observed.
No, I'm asking, did you observe that?
No,
You have no way of knowing exactly what that is except from what they're telling you, right?
correct.
What test did they do?
Well, I think they probably could smell it.
Do you know that? I'm asking, do you know what test they did?
Do I know what test they did?
Yeah.
I don't know if they tested it for
Fine.
fecal matter.
Okay. Nothing further. Well, just one last thing. None of these photos, except the cat, is what you saw, correct?
Correct.
Nothing further.
Any further objections, Mr. McFarland?
Well, the cat photo, if he's saying that's what he saw, I have no objection. But the others do not portray what he saw. And so I have a problem with the chain of custody on that. I'm objecting to those.
Thank you. Your objections go to weight rather than admissibility, especially considering the fact that for purposes of today's hearing, the rules of evidence do not apply.
Well, it's also going to admissibility because
Mr. McFarland, I've made my ruling. Thank you.
Oh, I didn't know you were making a ruling. I didn't know
Yes.
Mr. Brooks to make an objection or not.
Well, I've made a ruling on your objection, and now I'm inviting Mr. Brooks to do his voir dire and express any objections he may have.
Sir, who got to the apartment first, you or the police?
Police.
All right. Did you see those photos taken?
Which photos are you referring to?
The ones that you're submitting in evidence?
Did I see them taken? No.
So you can't tell this court whether those are accurate or inaccurate at the time the photos were taken because you weren't there, right?
Correct.
Nor do you know what the chain of custody is on those photos. Is that correct?
I wouldn't understand what the chain of custody for photos is.
You don't know what that means?
No.
You don't know where they've been?
Where these photos have been?
Yeah.
They were sent to me by law enforcement.
From the time they were taken until they were sent to you by law enforcement, you don't know where they've been, do you?
I'm not sure I understand.
That's called the chain of custody.
I'm not understanding your question.
All right, I'll just leave it at that. I do have other questions, but both Mr. McFarland and I are objecting to the introduction of these photographs. We have no testimony as to when they were taken, who took them, whether they accurately reflect the scene as they found it when they took the pictures, and last but not least, they have not identified a chain of custody, which may go to the weight, but my understanding of the court rules is the others that I asked do go to the question of admissibility. And for that reason, I object to their introduction.
Thank you. The objection is overruled for the same reasons, and I'll remind you, gentlemen, that you'll have ample opportunity to cross-examine and utilize the court rules during an adjudication hearing in the future, which you've already indicated that you intend to exercise that right. So for today's purposes, I obviously understand your objections, and I will give them due consideration, understanding that the rules of evidence have not been applied to this particular set of photos or this exhibit, but I do have to overrule your objections. Ms. Underwood, do you have any objections?
No objections.
All right. At this time then, Deputy Ames, if you wouldn't mind, I'd like to receive the photos whatever photos the department would like me to look at.
Thank you, sir.
Thank you.
Is this the ones that are coming from the witness? Is this the entirety of your photos?
Yes.
I have 8. Does that sound right?
Yes.
Thank you. All right. 8 photos will be regarded as Exhibit 1. Any other questions for your witness?
I do not have questions for Mr. Pernay at this time.
Cross-examination, Mr. McFarland.
No.
Mr. Brooks.
Sir, you have had a couple of opportunities to review photographs that I have submitted, which have not yet been admitted into evidence, but you've seen them twice, right?
Yes.
And do they appear to be clear?
Clear?
Clear.
Yes.
You mentioned that the house, compared to the when you saw it, appears to be cleaner. Am I right?
Correct.
But cleaner is a relative term. It could still be a mess, but be cleaner, right?
Correct.
How clean would you say those photos appear to show the apartment?
There doesn't appear to be any safety hazards, but I would like to see it in person.
I see. There are 14 of those photos, as I recall. Is that right?
I don't know how many photos there were. I didn't count them.
There were a number of them, weren't there?
Yeah, yes.
They appeared to cover a lot of different areas of the apartment, didn't they?
It's a trailer, but yes.
Well, all right, of the trailer. Did you see any indications in any of those photos that things were not up to standard?
No.
I believe on direct examination, you said that prior to this time, you had no reason to feel Mr. Johnson should have his children removed from his home, didn't you?
I don't understand. Could you repeat?
You said you had no problems with Mr. Johnson, no plans to remove them from his home prior to the police report.
Well, the most recent interaction I've had came from this police report. I've had prior cases with Mr. Johnson.
But you weren't removing his children as a result of it.
During those prior investigations, I did not remove his children.
To your knowledge, does he have any Child Protective Services record or background?
He does.
I have nothing further.
Underwood?
Mr. Cornack, I think there's been a little bit of confusion about what you saw versus what you didn't see. You indicated that you did see the cat firsthand, is that correct?
I did see the cat.
When did you go inside the home?
It was either the 16th or this. I believe it was the 17th.
Was it short, how long after the police went into the home did you go into the home?
I think it was less than 24 hours.
Okay. Was there still fecal matter in coolers and bottles? Did you personally witness that?
No, I did not.
So had the home been cleaned up then between the time that the police were there and the time you
So
came?
between the time of the pictures and the time that I was there, the house was cleaner.
Okay.
When I was there.
Okay. But it's your testimony or your understanding that the photos that were taken were within 24 hours of when you made
So
contact?
I would have to check my records as far as when the police were there. I don't know what time they were there. And I don't remember what time of day I was there.
But it was within a very short period of time, within a day or two at the most?
I'm pretty comfortable in saying it was less than 24 hours.
I have no further questions.
Any redirect?
No, Your Honor.
Any recross? Gentlemen,
No.
thank you for your testimony. You may return to your seat.
Thank you.
Any other witnesses? Ms. Thomas?
No, Your Honor.
Mr. McFarland?
I have one question for Ms. Cornack. Mr. Cornack, if I can have him up there.
What? I just asked you.
I know you did, but it just occurred to me, Your Honor.
All right, well, you're still close enough to the microphone.
I got me on.
Agreed.
I tried to wait so you didn't go all the way back to your seat.
I appreciate that.
When you viewed the home, was it suitable for children to be living?
It was borderline. I couldn't tell. So the problem was the house was raided. So I couldn't tell what was from, just, I don't know the right word.
Tearing things?
Yeah, I don't know what was from that and what the house was like prior to that. Because like the kids' bedrooms were okay. The living room was okay. I believe Mr. Johnson's room was in the back of the trailer, and that room wasn't accessible because the bed was on its side. It looked like it had been raided.
Let's say that, I believe Mr. Brooks will be able to introduce the photos. If it shows that the house is fine, would you then still request removal if the house was suitable? Now,
Yes.
if father were to take daily drug tests or random tests and the house was suitable, would you still request removal?
I would have to talk to my bosses about that.
That's not a decision you can make.
It would be a decision I'd be part of making.
Fair enough. Nothing further.
Any questions based on Mr. McFarland's questions?
No, I have no further questions. And if there are no other witnesses, I have witness of my own accord.
Thank you for your testimony. You may return to your seat. Mr. McFarland, do you have a witness?
Yes, Your Honor, my client will be very brief.
Very good. Deputy Ames, if you could swear in Ms. Malika Rumber. Yes.
Can you hear me okay, Ms. Rumber?
Yes,
Please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
yes,
Malika, I'm stepping up here where you can see me. Can you hear me okay?
yes, I can.
You and I had a chat before court. Are you aware that we had to be in court today?
Yes,
Okay. What is your opinion? Do you want the kids to remain home with their father, or would you like them with the paternal, which means the father's dad, the grandfather, or would you want them someplace else? Do you have an opinion on that?
yeah, I do. I would like the kids to be at home with their father. He's a really good father. And I just also want to state that whatever I have on my allegations don't go on his case too. But yeah, I do think that the kids should be at home with their father.
Okay. Thank you. I have no further questions.
Questions, Ms. Thomas?
No, Your Honor.
Mr. Brooks?
No, Your Honor.
Ms. Underwood?
Ms. Rumber, do the photos that were shown by Mr. Cornack concern you with the dead kitten and the fecal matter in the home and the condition of the home and the police rated it?
I wouldn't be able to speak on any of the photos that were shown because I wasn't there at the time. I was in jail.
If all of the photos were accurate representation of the condition of the home, would you be concerned with your children living in that type of environment?
I'm going to object to the question because it presumes facts, not evidence.
It's couched as a hypothetical question, so I can't grant the objection on that basis.
If they were the accurate, I don't really know how to feel about, I don't know because I was in jail at the time. So I don't know how to feel about that. I don't know if the cat was there in the house. I don't know if it was an outside cat. I don't know what was actually found on the sheets, on the blankets. I don't know if that was actual fecal matter. I don't know. So.
But if it was, would that be concerning to you?
Yes, if it was.
All right, no further questions. Thank you.
Ms. Rembert, you're coming to us from a rehabilitation facility now, is that right?
Yeah, I am.
Okay, and how long have you been there?
I've been here for a week.
When were you arrested?
September 6th.
I know we've already had your adjudication, but at the time that you ended up in jail, were you using drugs?
Before I ended up in jail, yeah, I was using drugs. So I've been clean for quite some time now.
Good, that's good. What drugs were you using, if you don't mind me asking?
Cocaine and meth.
All right, well, I'm glad to see that you're getting help for it. Thank you for answering my questions. I have to offer an opportunity to the other attorneys to answer any questions they may have based on my questions. Ms. Thomas.
Ms. Rembert, prior to your incarceration, where were you staying?
I was staying at my apartment on 3.
Okay, so you were not living with Mr. Johnson?
No.
Okay, and are you currently pregnant?
Yes.
Is Mr. Johnson a potential father?
No.
Okay, thank you for that. No further questions, Your Honor.
Any other questions, Mr. McFarland?
Yes. Malika, from where you are, could you even see the photos that Mr. Cornack was holding
No,
up?
I could hardly see them. It's kind of blurry from where I'm my end. So no, I couldn't.
So do you think you can make an honest opinion without accurately seeing the photos?
No, I couldn't.
Nothing further.
Mr. Brooks, any questions?
Did you see the picture of the dead cat?
I could hardly see the cat.
I'll ask this question as a follow-up. Do you recognize that cat?
No, I don't.
Did you have a cat in the house when you lived there?
I object,
No,
Your Honor.
I
My client's
have- no.
testimony, I object, my client's testimony was she didn't live there, that she gave an address on Church Street, I believe.
Is that, which rule of evidence is that objection to be evaluated under?
Well, he's taking things out of context. He's saying when she lived there, and that's not her testimony, that she lived there.
Thank you. The objection is overruled. You answer the question. She's kind of already answered it. Ms.
Well,
Rumberg.
yeah, what I really want to know is, do you recognize that dead cat?
No, I don't. I know.
It was never your cat.
No.
You don't know if it was an indoor or an outdoor cat.
No, I don't.
Do you even know whether or not it's Mr. Johnson's cat?
No, I don't know.
That's all.
Ms. Underwood, do you have any questions? I have no questions. No witnesses. Any other witnesses, Mr. McFarland?
No.
Mr. Brooks?
I'd like to recall Mr. Cornack.
Mr. Cornack, you're getting your steps in this afternoon. Come on up.
I just like your pretty face.
I like yours too, Mike.
You remain under oath. Have a seat.
Slide that. So like face.
Mr. Cornack,
Yes.
are you familiar with a document called the DHHS Policy Manual?
The policy manual, yes.
There is a section in that policy manual dealing specifically with controlled substances. It's sections 8 or 9. Is that accurate or not?
I don't know the numbers, but
Would you agree it's there?
yeah, it's there.
The very first line on that paragraph says, and I quote, "The mere presence of controlled substances is not grounds for removal of children from the home." Have I misquoted it?
No.
Next question. What evidence of harm did you find those children were exposed to by what you presume was an accurate test of drug residues performed by the police?
Well, my concerns would be that the police had bought drugs out of the home where the children were residing, that they found drugs in the home.
How is that different, or how does that contradict or override, better word, the statement I just made to you from the first line of the Department of Human Services Policy Manual?
I'm just going to object to this categorization of a direct quote. Without a citation, there's no way for us to know whether it's accurate or not. I know that Mr. Cornack has agreed that that's what it says, but I'm not comfortable accepting that without further indication of a proper cite.
I don't know, she can object to her client's own testimony.
Well, I did give you a cite. It's chapter 8 or chapter 9 of the department's policy manual involving.
Do you know how many manuals the department has, Mr. Brooks?
I have them all.
Okay, well then can you please provide me a cite?
Chapter 8.
Of which manual?
I can't give you that, but I'm going to say if that's what we're gonna play here today, I want this rescheduled for when it was scheduled for originally, because I have the manual. I just didn't know I should bring it today. It says what I said it says. If she wants to keep that objection, that's fine, but I want an adjournment.
I've got Thursday morning available.
Your Honor, I don't think that there's grounds for adjournment. I'm simply asking for a cite so we can accurately ensure that whatever presentation or argument Mr. Brooks is going to make is appropriate. And if he wants to bring it up, then he should have had the citation for it already.
It's, it's not quite confined to that particular issue. I also know that Ms. Underwood has conflicts this afternoon. And we also have another case scheduled to begin this afternoon. So legitimately, we may have some additional things to consider in deciding whether or not we can accurately get through everything that needs to be sussed out this afternoon.
However, if I may, I can't stay for probably about another 15 minutes, but my take on just the argument or the objection here is that, again, you can apply the weight of the testimony to what Mr. Brooks is stating, and Mr. Cornack is saying, and again, also take into the totality of the circumstances which brought this case here, which is not just the presence of drugs when making your decision.
That's true too, Mr. Brooks. I have, in fact, had the court rules open to me for some time, which does certainly remind and guide all of us that it's about whether or not there is an actual risk of harm to the children. It isn't necessarily that they have been harmed, but if there is a significant risk of harm. And so that is what guides the court in making its decision today, rather than the citation to the department. So I would overrule your request for adjournment purely on that particular point itself, but reassure you that I remain focused on what the court rule directs me to.
May I continue?
We've got apparently, well, around 15 minutes is about good. Yes.
Would you agree with me that in order to remove children, there has to be an unreasonable risk of harm?
There has to be a risk of harm.
I can't hear you.
There has to be a risk of harm, correct.
An unreasonable risk of harm.
Unreasonable, correct.
The children, as far as you know, didn't test positive for drugs, probably weren't even tested.
Correct.
They didn't appear to have been physically harmed in any way, did they?
No.
Did they appear to be emotionally distressed aside from the police raid?
Aside from the police raid?
Yeah.
Oh, I said no.
Oh, I didn't hear you say no.
I apologize.
I apologize too. What harm? What unreasonable risk of harm?
Objection asked and answered.
No, it wasn't. What unreasonable risk of harm did you observe in those children in that home?
He does have the right to cross-examine using the same questions that were used in direct. So if you would like to review that with Mr. Cornack, he does have the opportunity to have to overrule your objection.
Could you restate the question?
What unreasonable risk of harm did you observe in those children the day or the night, as the case may be, when they were removed from my client's home?
My case is based on what law enforcement found in the home when the house was raided, plus the positive drug screen.
That's it.
Correct.
I have nothing further.
Right. Ms. Underwood?
No additional questions.
I have one question.
Ms. Thomas?
I have none, Your Honor.
Mr. McFarland?
I didn't hear an answer, a direct answer to Mr. Brooks' question, is what unreasonable risk of harm do you personally view? Not reports or whatever, but what do you personally view?
What did I view? The cat. I did the drug screen, and those are the two. Yes.
And was the level of drugs in father's system enough to impair his ability to safely watch the children?
When I don't know that I can answer that. I don't
Fair
know
enough. Fair enough. Nothing further.
Thank you for your testimony. We are adjourned to your seats.
Thank you.
Okay, Mr. Brooks, anyone else you'd like to hear from?
Stephen Johnson.
Mr. Johnson, come on up to our witness stand.
Raise your hand, please, sir. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
I just stepped there.
Mr. Johnson, good afternoon, sir.
Good afternoon, sir.
A week or two ago, your 3 children were removed from your home, is that right?
Yes.
And that was as a result of a police raid
Yes.
on your home?
Yes.
You've seen the photographs, which we've objected to and been overruled. But you've seen the photographs showing little pieces of white paper, which they say have residues of drugs on them. Did you see those little pieces of white paper too?
No, I have no knowledge of what was found.
All right. You've also seen the pictures of the house.
Yes, today, yes.
Your house was, the word I heard used once or twice was, quote, raided. How would you describe the home? Or the presence of the police?
To what specifics?
You're gonna have to speak up, sir.
To
Your
what-
lawyer's an old man and I don't hear.
I'm sorry. To what specifics are you concerning to? Because that can be different scenarios as far as visual or the drug raid part, police part, the living conditions. Are you going towards?
Did they tear up your apartment or your house to any significant extent?
Yes.
Flip over furniture, open drawers, dump them out?
Yes. Trash, everything.
The pictures that were taken, were they, that were submitted by the prosecutor, or by the DHHS lawyer, were those taken after the raid?
No,
They were taken before the police came?
no.
Maybe you don't understand my question. You've seen the pictures. May he see those pictures, Your Honor?
Witness has the exhibit.
Yes, I'm familiar with the photos.
Did the police cause any of that mess?
Yes, if that's what you're asking, because a lot of the things that I see placed in the photographs were not in particular areas of the home which were taken on the photos.
When they entered your home, where you were there and your 3 children were there,
Yes,
was
sir.
that the condition of the of your home?
Not at all.
Would you, now, at my request, instruction really, I told you to clean up the mess that's there, didn't I?
Yes, yes.
You took pictures also at my request, didn't you?
Yes, sir.
Did you bring them with you today?
Yes, I did.
And to the best of your knowledge, they have been shown to the opposition, is that correct?
I believe so. Yes.
Where are they right now?
They're on your desk, I believe. I didn't grab them on my way.
Sir?
Who took those pictures?
I took these photos.
When did you take them?
I took them on 11/7/24.
At the time those photos were taken, did they accurately reflect the images which are depicted on each of those pictures?
Yes.
And where have those pictures been since you took them? The documents actually in your hands.
Oh, they've been with me waiting to get to court.
Nobody else.
No, sir.
I move for the introduction of, I think 1 through 14, or A through Z or whatever it would be?
Objections?
No objections.
No objections.
Thank you. I will receive those as well. Thank you.
Sir.
So are you finished with the exhibit with Mr. Johnson?
I am.
All right, thank you. I'd like to receive that one next as well. All right, so I now have to the bench the 14 photos from Exhibit A, as well as the original photos from Department under Exhibit 1.
Have your kids ever been in the HS, have they ever been removed from your home before?
No,
How old are they?
4, 3, and 1.
But for this intervention by the local police, have they ever been taken by anybody else, any custody fights or anything like that?
Never had any child removed from me.
Have they always been under your care?
Yes. No.
Well, I don't mean overnight babysitting or something. Is there anything else you want this court to know?
Just one thing regarding the photos that was taken at the, the photos that are placed in by the opposition was photos of my house up under reconstruction at the time. And that's why it appears to be different than the current photos, because like I explained, it was under reconstruction. We were doing a lot of work. It's a rental property and they caught it in the middle of the house looking like that.
If this judge walked into your mobile home right now, would it look like the first set of pictures or the second set?
Second set.
That's all.
Questions, Ms. Thomas?
Mr. Johnson, at the time of the police went into your home on October 16th, what reason did you give them that there was urine and fecal matter in coolers and all over the place? What was the reason you gave them?
Well, I didn't give any reasons because I didn't give any statements. I didn't talk to the police. I was in handcuffs, detained inside of the car while they performed the search. I didn't have no visual search.
So, Mr. Johnson, I'm reviewing a police report today, and I didn't intend to admit this, but since you're here, it states, Stephen stated that fecal matter and urine located in the residence were not his or his children. You didn't say that?
Yeah, because I don't use the bathroom in the cooler, so of course it's not mine. Whatever they found obviously wasn't mine. If I had it, I don't know, it wasn't mine, that's all I know. It wasn't my kids, because we don't perform our hygiene like that. We have bathrooms, we don't need to do anything like that. So of course I stated that at least. It also states on there I was confused on what he was even talking about.
So you're familiar with the police report?
Well, I haven't seen a police report. I'm just familiar with me being confused.
Okay. So fecal matter and urine were inside of a cooler that was in your room near your bed, and your phone was in it, and you don't remember seeing fecal matter or urine in that cooler?
I have no reason to have urine myself in a cooler. Like, that's what you're asking. And I would never have my phone inside of a cooler full of pee and poop. Phones are too expensive.
Your Honor, for purpose of impeachment, I'm going to ask the court to accept this police report.
I'm going to object. It is not clear to me to what extent the chaos documented in that police report, and actually by those photos, was pre-existing before the police entered the place. For example, counsel's just been asking questions about an ice chest on the bed with fecal matter in it. How would that, you didn't notice ice chest with fecal matter on your bed? Well, maybe not. Maybe that was placed there by the police in doing their, what I assume was a pretty thorough search of his home. And if that's the case, I object to the police report if it attempts to describe in detail the chaotic condition of his home.
We have hit our 15-minute mark, and I think the police report is pretty relevant. The reason that we're here today is because the police raided Mr. Johnson's home. I would like to give Mr. Brooks, Mr. McFarland, and Ms. Underwood a chance to look through that police report as well, especially Mr. Brooks, in case there are any questions and he wants his client to carefully navigate for purposes of the removal hearing, obviously without compromising any of his Fifth Amendment rights on anything else. But that's why we're here, is because I have to decide whether or not there's a substantial risk of harm associated with allowing the children to return to the home. And I also understand this has been balanced by a safety plan that's been in place. I have some time to continue this to Thursday at 9 o'clock.
When we were originally scheduled at 5, I'm not mistaken. Is that right?
It was one of the times we talked about.
Thursday at 9.
Question, Your Honor, on your comments. Are you saying that the police report has already been introduced? I missed that. Or are you saying that it should be presented to all attorneys before next time?
Mr. Brooks has had a chance to lodge his initial objections. I don't think everybody else has a copy. True or false, Ms. Thomas?
Your Honor, that is correct. I didn't have a copy either until just right now, because typically police reports are not admissible, but for purposes of impeachment, I plan on using it, and so I will provide a copy to the attorneys of record as soon as possible.
Well, and for purposes of the preliminary hearing, the rules of evidence do not apply. So it would be something that I would take a look at, obviously understanding that the weight is questionable. It's a police report, it's got layers of hearsay within it, but it is something.
And I will email counsel a copy of the relevant portion of the DHS policy manual that I've discussed here today.
Very good. So understanding that obviously there will be some hearsay objections, do you have any other objections to the police report? Understanding we'll give you an opportunity to cross-examine on Thursday, Mr. Brooks.
No, I have nothing.
Mr. McFarland.
No, Your Honor. I haven't had time to explore that issue.
Ms. Underwood.
I have no objections.
Very good. All right, I'm gonna receive a copy of that as well. If you would please circulate that, Ms. Thomas, to everyone. I didn't have a chance to look at it before we come back Thursday. I'm not gonna make any rulings in the interim, and I'll see you all. Can maybe put together a copy for everybody before they go.
Sure.
Thank you, Mr. Johnson.